Mr. Nervig, you may proceed.
Thank you, Your Honor. May it please the court, counsel. In this case, Iowa courts have ordered the eviction of 30 families from their homes and declared that the rights of the evicted citizens are irrelevant and denied them any opportunity to express their views. I'm Jim Nervig, and I represent the appellant, Mark Ogden, who's the owner of the mobile home park in which the homes are located. I will address the court first and then yield the remainder of my time to Laura Jontz, the attorney for some of the evicted individuals. The Constitution guarantees to every citizen, including our very poorest, the right to equal protection.
There's an issue here is whether or not you preserve the constitutional arguments. And I think that's important because if it's not a constitutional question, it may not be a de novo review, it may be an at-law review. So tell me, number one, did you preserve the constitutional issue? And number two, what's the standard review? And how did you preserve it?
Your Honor, this case was brought in equity by the city of Des Moines seeking injunctive relief. The standard of review is the standard of review for any equitable case. We have a situation here where the city of Des Moines has a basis for taking away the constitutionally protected right of parties to have grandfathering of nonconforming uses under Iowa zoning law. The fundamental basis for the grandfathering of non-conforming rights is the takings clause of the Iowa and federal constitutions. They guarantee against takings without just compensation. If that right were not protected by our Constitution and our judicial principles, then a city could come in and merely rezone property, as they've done here, take a mobile home park, rezone it to a zoning classification that does not allow mobile home parks, and then say, you have to get out. No compensation, you have to get out, you're in violation of our zoning. It's a time-tested principle in Iowa under the Constitution that parties have.
But that's right, but, and I don't think that's really disputed. The question is whether the use has changed over time. The law is pretty clear that if you substantially change the use, those vested rights no longer apply. And in this case, at least, if I understand the city's argument, I mean, they are suggesting, well, there's now a substantial increased fire hazard. And you had the fire marshal testify, and based on not only the location of the mobile homes, but also developments since 1955, which include, I think, some building of structures and placement of other materials between the mobile homes and so forth. Now, I'd like you to address that argument. I mean, the city's basically saying, look, now we've got a safety issue because the use has changed.
And my argument to that really is based on 37 years of practice as a city attorney in Iowa. I was city solicitor for Iowa for 8 years in the 1980s. And as city solicitor, one of my responsibilities was overseeing city nuisance abatement actions. And those nuisance abatement actions largely were founded on safety issues. And I'll just tell you, I never even contemplated any kind of action like this on a safety ground. And I'll just tell you how I would have handled it and how the city should have handled it. In the action in the district court, what did the facts show? It showed there was 77 years in which this park has served as a residential neighborhood. The city never before in 77 years contended that the park was an unsafe neighborhood. At trial, the city presented no evidence that the park has become unsafe for the 30 families who live there.
Well, wasn't it the fire chief or was it the police chief who said there is increased danger of fire?
No. When I would ask the court, please, read very carefully the roughly 5 minutes of testimony of the police chief, because I was going into that trial thinking he was going to be my main expert adversary. He was anything but. He indicated just generally, with respect to mobile home parks, when you have a close proximity of mobile homes in a mobile home park, safety concerns.
That's been the case for 50 years or 70 years or whatever.
Well, he just indicated that's in general a problem with a mobile home park.
Is there any testimony about the increased impediments?
No. And I'll just say, again, as a city attorney, and I just have a new city now that's come on board as an outside client, and one of the first things on our agenda is dealing with a mobile home park. And what we're going to look at is things like debris and impediments. We have great tools for cities under Iowa law to deal with those things. And the basic and one of the most effective is our municipal infraction law. You can get a municipal infraction citation against somebody to get $750 a day fine for violating city requirements. So things like the debris and whatever, if I was city attorney and I was dealing with this case and the city came to me and said, we got this problem, I'd say, well, let's do a civil municipal infraction for those impediments.
You're not disputing that they can issue citations for all the individual issues,
Not at all, Your Honor.
if there needs to be lighting or fire extinguishers or there's junk or debris that needs to be cleaned up, they can do that. Your issue is the viewing the mobile home park as not in compliance with zoning because of the positioning of these pads that's the same as it's been for 60 years or whatever.
Well, yes, again, as a city attorney, you look at, when your council wants you to look at non-conforming uses and whether it's expanded, you look at the physical layout of the park. It's like that Okoboji case with the marina. A mere intensification is irrelevant to expansion. So the marina may have had 20 boats at it at the time it became a non-conforming use, and it may be serving 40 now. And unless it actually expands its geographic boundaries, that's just intensification. So again, the city and the courts, I think the courts were overwhelmed by all the different citations that the city gave beyond the simple ones like, did you have enough fire extinguishers and was there debris? And there were all these setback issues that were raised. Mark Ogden didn't have any chance to comply because he didn't need to comply. He had a non-conforming use. He didn't have to comply with those setback requirements. Again, Mark Ogden owns the land. The residents own their own mobile homes. And what we had physically then in the park was we had 39 mobile home pads. The record was clear, 77-year-old mobile home park with 39 pads on which 30 mobile homes are located. So consider that. Originally, there were 39 mobile homes on 30 pads. Now there are 30 mobile homes on the same pads. Those pads are concrete pads. They haven't moved. The other big issue that was raised by the city was the driveway not being the current standard driveway. Well, again, you know what wheelbases on cars are and trucks. We don't need some monstrous ladder truck to come in if there's a fire in a mobile home when the highest structure is a mobile home. The driveway was there, and again, the key witness in this case is the fire marshal. And he honestly testified that, there's a driveway, but he didn't see that driveway issue presented an issue with the park. So again, there was nothing in this record to indicate there was any public safety violation. Again, if there were other violations, and again, if we made the record, we would show that my client has dealt with the fire marshal and got his fire extinguishers approved and what have you. That isn't in the record. But even if he hadn't, the city has a much less restrictive alternative than going in and this is like taking a nuclear bomb and blowing up a neighborhood. We have 30 families at issue here, and to eliminate those 30 families over the minor arguable safety violations is totally beyond the realm of reason. And now I'll yield the remainder of my direct time to Laura Jontz.
Mr. Nervig, thank you. Ms. Jones?
May it please the court, counsel. I represent the amici in this matter, and they are individuals who own homes in Oak Hill Mobile Home Park. Now, this court's decision will impact the city of Des Moines, and it will impact Mark Ogden, but it will likely have the largest impact on the individuals who own homes in Oak Hill Mobile Home Park. So this is a zoning matter, but this is also a matter involving home ownership. Approximately 30 mobile homes are located in this park, and the individuals aren't renting these homes, they own them. These homes are their largest asset, and they're also their place of shelter. Now, Oak Hill Mobile Home Park is not just a mobile home park, it's a neighborhood. It's an affordable, safe housing neighborhood for these individuals. And lot rent in this park is approximately $300 a month, and these individuals own their homes, which means that their cost of housing for the month is approximately $300. So this is affordable housing for low-income individuals in the Des Moines area. And the word mobile...
What hardship would they face if they were evicted? Could they simply move their homes to another location and pay the same rent?
Yes, Justice. This is a misleading term. The term mobile home, we think this home can just be transported to a new neighborhood. However, when you do look at issues addressed in our brief, you can see that the cost of moving a mobile home is excessive. It's $5,000 to $10,000 just to relocate a mobile home from one park to another. So that's a cost that most low-income families definitely cannot bear. In addition, the homes in this case are not new mobile homes. They're mobile homes that have been there for many years. And these mobile homes, if they're moved from the park, assuming that can be afforded, they're going to be compromised. And the structure of these homes, there's going to be repairs that, again, the low-income individuals cannot afford to bear. So this is not a situation where individuals can just move to a new location. This is a very serious situation that will involve individuals being without their homes. And the individuals that I represent were not given notices. They were not given official warnings by the city. They were not a part of this lawsuit. They weren't given a chance to participate. The city did not tell these homeowners to make any changes or improvements on or near their homes.
And you make a lot of compelling practical points, but isn't the legal issue that's before us, isn't that really focused on, is this a zoning violation? And if it is it protected because it's a pre-existing non-conforming use?
An argument there, Justice, is that this is a legal non-conforming use, as Mr. Nervig stated, that the issues that may be addressed by the city are the expansion of this use and the health and safety violations. And the safety and health issues listed in lower courts' rulings were materials such as fences, container gardens, bicycles, refuse items, but these are items that are used by individuals in a neighborhood. These are not items that expanded the use of the trailer park beyond its use as a neighborhood and a place that provides affordable housing. And to address the standard of review in this matter, we're looking at an injunction. The remedy in this matter is an injunction. And as the dissent said in the Court of Appeals, Judge Danielson, that We're looking at whether there's an invasion or threatened invasion of a right, that substantial injury or damages will result unless that injunction is granted, and that there's no adequate legal remedy. And so this is what we're arguing, that there are other legal remedies.
Really, you don't hold the government to that highest standard. I mean, that's the standard that applies for a private party, but for the government, you don't necessarily hold them to that standard, right?
Well, and we believe since the remedy is an injunction, that we're still looking at a balance of harms. Both parties did address in their briefs to the Court of Appeals that the standard should be a de novo standard. And when looking at the balance of harms in this, the harm that could be endured by the city and the harm that could be endured by the homeowners, that the homeowners face homelessness. If these individuals are forced out of their homes, they likely will become part of Des Moines' homeless population, thereby increasing the problems the city may have. I see my time is almost up. Thank you.
Counsel, thank you as well. Mr. DeSmet.
May it please the court, counsel. There are two things that I want to discuss at the outset in response to Mr. Ogden's arguments. The first thing I think that's important to recognize about this case that's different from past non-conforming use cases is that the layout and the conditions at Oak Hill Mobile Home Park that exist today are not compliant with the zoning ordinances that existed when it began being used as a mobile home park. In past cases, the court has looked at use of property began, and then later the city passed some zoning ordinances, and when the use began, there were no zoning ordinances regulating how that property was to be used. This case is different, because in 1955, when the property began being used as a mobile home park, city ordinances already required that there be a 12-foot separation between each mobile home, that there be a 20-foot wide access driveway.
Am I wrong in thinking that it started in 1941? Where did I get that from?
I believe you got that from Mr. Ogden's brief, but I do believe that's incorrect, and there are a couple of reasons that's incorrect. First is that the 1947 aerial photo that's in the record shows that in 1947 the property was still being used as a tourist camp. The buildings that are shown in that photo are not consistent with a mobile home park. And so we have that clear photographic evidence that the use as a mobile home park didn't begin until after 47. The second piece of evidence we have about when the mobile home park began being used is the R.Appel directories, which Ms. Donovan testified to at trial. She had reviewed those directories, and what those are is an address by address review that the city buys each year, where this company goes out and looks at the address and then puts into the directory what that address is being used for. Those directories indicated up until 1954 that the property was still being used as a tourist camp. The 1955 R.Appel directory is the first one that indicates this property was being used as a mobile home park.
But you issued an occupancy permit back then. And
Yes, Your Honor.
if it didn't comply with the zoning code then, why would you issue an occupancy permit?
I think the occupancy permit is good evidence that the property was compliant with zoning ordinances at the time. The ordinances that existed said that an occupancy permit wouldn't be issued unless the property was compliant with the zoning or with the ordinances that existed. And so the fact that the certificate of occupancy was issued is evidence that whatever the layout was, it was compliant with the setback and separation requirements that existed at that time. Sometime between then and 1963, the layout of the property changed and became non-compliant
But
at
I
that
mean,
point.
on a de novo review, and I guess the Court of Appeals did substantial evidence, but neither of the parties here disputes its de novo review.
I dispute that.
Oh, okay, you do. I thought in your brief you accepted that it was de novo. But on our review, can't we say it's a lot, there are no other photos. The only photo was that 1963 photo that looks very similar to the situation today. Isn't it more likely that we have an original non-conforming use? Can't we draw that inference as opposed to the inference that something happened in the late 50s, early 60s where the park expanded, when that seems to me just utterly speculative?
If the court accepts that view of the facts, that the layout of the park in 1955 was relatively the same as in 1963 and as today, then Mr. Ogden has failed to meet his burden on a non-conforming use analysis that use of the park was ever lawful at any time in the past. Because what the Crow and Rubel cases tell us is that we look for at that certificate of occupancy and ask, was it valid when issued? And if the layout of the park was not compliant with the 1955 ordinances, then that certificate of occupancy was invalid when it was issued, and it has no legal effect to protect that continuing use as a mobile home park into the future.
Tell me why you think it's substantial evidence when you brought an injunction.
The standard review that we look at is that we look for correction of errors at law, and we give deference to the district court's fact findings.
Why under an equity action?
Because that's what our prior case law, the court's prior case law says about zoning matters. I don't recall the site offhand. I know it's in the brief.
But, I mean, as I read the transcript, and I didn't read it all that carefully, it seemed like the judge took everything into evidence and reserved ruling on the objections, which is consistent with equity, isn't it?
Yes, Your Honor.
And I do read your brief at page 8, you say, as a matter tried in equity, the court's review is de novo, right?
Yes, Your Honor.
Okay.
Let's talk about, let's just hypothetically assume that the use did predate 1955. I know you dispute it. You argue that the use has changed, and it's based on a number of things. Some of the aerial photography and the bicycles and structures and so forth. Yet, I did find the quote I was kind of looking for about the increased danger from fire. It was stated that it was because the buildings face greater danger from fires if closer together than further apart. It wasn't based on, at least my reading of it, the various obstacles that were scattered around. What compelling record to suggest that there really was an increased fire hazard from what you had in the past?
Well, the increase in the size and the decrease in distance between the mobile homes is something that increases the risk of fire, because every time someone puts an addition onto their mobile home, adds a
Weren't
porch.
the pads in the same place as they were earlier?
The district court correctly found that even if the mobile homes are in the same place, the mobile homes themselves have expanded. People have added porches, people have added additions to the living space of their mobile homes. That decreases the space between one mobile home and the next, increasing the chance that if a fire breaks out in one, it's going to spread to the other. And every time someone does that, they add a porch on, then they're making a new violation of the ordinances that existed in 1905 and increasing that risk that there's going to be the spread of a fire. The things that are around the park, the yard waste, tires, and other things that are shown in the photos that are in the appendix further enhance that risk, because they make it easier that, you know, if one mobile home starts on fire, start the yard waste next to it on fire and more easily transmit that to the next mobile
But
home.
the fire marshal didn't say that. He was giving generic testimony. His testimony was 3 pages.
Yeah.
And it was all generic about the closer it is, the worse it is, the narrower the driveway, the harder it is to get in, but he never related it to this place. He never gave an opinion as to this place. But, you know, my real question is why now and not in 1963, of all this stuff in 63
Well,
was apparent?
I'd like to address both of those points, Your Honor. I think it's a mistake to read Fire Marshal Lund's testimony in isolation. He testifies that the closer building structures are to each other, the greater the risk there is that fire is going to transmit from one to the other. And Ms. Donovan testified about the fact that today, many of the mobile homes at Oak Hill are closer together than was intended by the ordinances that existed in 1955. And when you look at those two things together, you see the increased risk of fire at Oak Hill. The reason that the city has not taken action before has to do with the way the city enforces zoning laws. We simply don't have the staff to go out and examine every property in the city of Des Moines for zoning compliance. We operate on a complaint basis.
But 60 years?
We operate on a complaint basis. When a complaint was made, we went out, investigated, and we took action. And if, for whatever reason, no one...
Who filed the complaint in this matter? Because my review of the record indicates that it was simply a matter of the city council asking city staff to go out and review all non-conforming uses. And then all of a sudden that brings it up and results in the letter on August 5th of 2014 about this particular am I wrong in that summary of how this all came up? It wasn't a complaint, or was there a specific complaint from somebody about this?
There were complaints, Your Honor. If you look at page 199 of the appendix, Ms. Donovan testifies that there were complaints from the public. The record doesn't go into any more detail about what those complaints were or who made the complaints, but the record does contain evidence that there were
But on
complaints.
cross-examination, doesn't she admit that it simply came from a recommendation from the city council that they should investigate all non-complying uses, including this mobile home?
Ms. Donovan does discuss that the city council had directed a review of all mobile homes. She also testifies during cross-examination that there were public complaints about Oak Hill.
Could you address your opposing counsel's argument that 30 families face homelessness, and if in a court of equity in balancing the harms, why wouldn't the city take measures such as cleaning up the debris, perhaps removing some porches, doing those things instead of an order leading to the eviction?
The city picked the zoning enforcement action because it gets at the systemic problem that the park itself is in violation of zoning ordinances. Cleaning up debris isn't going to bring the park into compliance with zoning ordinances. We're focused on the recognized and existing risk of harm that exists at Oak Hill. The idea that these people are all going to become homeless is a speculative harm that we don't know whether that's going to happen. And so the city is acting to take action on the risk that we see existing right now.
When you say it won't bring it up to standards, it may not bring it up to today's standards, but will it bring it up to the 1955 standards?
Simply removing junk and debris would not bring it up to the 1955 standards. There would
The
still,
junk and debris is really a red herring.
I think the junk and debris is an additional issue that makes the park more dangerous to live in, but
Not a zoning violation.
the junk and debris by itself is not a zoning violation.
What is your position about whether or not that the constitutional taking claim has been preserved for our review?
It has not, Your Honor. At the district court level, Mr. Ogden made the argument that this is a non-conforming use and discussed the fact that the non-conforming use derives from a constitutional takings clause, but the argument that this was an unconstitutional taking was never made.
If we affirm the district court, though, and you order these people to leave, doesn't each individual one have an inverse condemnation claim against you? Because you're taking their property? They have some property interest in a leasehold there. I mean, wouldn't that give rise to 30 different constitutional claims?
They don't have a property interest that is continuing. They lease land from Mark Ogden, and he could decide to end that lease at any time and kick them out. And
What the leases say?
I haven't read the leases, Your Honor.
So how can you kick them out at any time? If you have a year lease, how do you kick someone out?
I don't know that the leases are a year, but these people do not have a right to be on that property permanently. Their right to be there is subject to the will of Mark Ogden and how long he wants to let them be there. Furthermore, if they have a situation where they were told that this was an acceptable place to live and that turns out not to be true because the property is in compliance with zoning violations, then I think that they should be looking at what remedies they have against Mr. Ogden and not what remedies they have against the city for allowing them to live in this park that has the safety issues that exist and pay rent for really very little benefit from Mr. Ogden.
I just want to allow you to respond. You indicated earlier that you believe that the trailer park was in compliance with the 1955 Code of Zoning Ordinances at that time, but in the August 5th, 2014 letter, she provides multiple examples of the violation of 2A of the municipal code. 39 of the municipal code includes about a dozen different failures to provide setbacks and all these other things that we've been talking about, but they still issued a certificate of occupancy at that time, did they not?
A certificate of occupancy was issued in 1955. The 2014 letter, I don't believe it indicates that an opinion that the layout of the park in 1955 was the same as it is today. I think it indicates that the layout of the park as it is today violates the 1955 ordinances.
Well, but she indicates that there are two controlling ordinances relating to mobile home parks in effect in 1955. Then she goes through these lists, shows that it's not in compliance at all at that time, and still then issues a certificate of occupancy. Am I wrong in that summary of facts?
Ms. Donovan did not issue a certificate of occupancy in 2014.
No, the city did.
Not in 2014, in 1955.
As a result of her research, she says that it was completely out of compliance. I'm just going to say there was a dozen violations of the municipal zoning code of Des Moines in 1955, her research determines, but still in 1955 then, the city issued a certificate of occupancy for this non-conforming use, did they not?
I don't believe that Ms. Donovan's letter says that the layout of the park in 1955 was non-compliant. My understanding is that it says the layout of the park today is not compliant with the 1955 ordinances. And the reason the 1955 ordinance is where we look is because that's when the use of the property as a mobile home park began. And so, we're judging it against the conforming use that the certificate of occupancy was issued for. I see that my time is up. Thank you, Your Honors.
Thank you as well, Counsel. Rebuttal?
Thank you, Your Honor. First, to correct the record, the issue of when the mobile home park started was shown by reference to the records from the Polk County assessor that showed those 39 pads were in place well before 1955. With respect to, I'm thinking about Justice Mansfield's comment because, and this is a real big concern to me, that typically courts do defer very greatly to statements of purpose set forth by our enforcement authorities. And that's a huge problem, and maybe my biggest problem with this whole lawsuit is we have a situation here where, in my considered opinion, the city attorney is pursuing this action for the sole purpose of gentrification, beautifying the city by eliminating the poor, even to the extent of not allowing the poor the right even to be heard in the action when their homes are taken. And I cited for you in my additional authority application a couple of cases involving President Trump's immigration order.
I mean, you have sort of two theories in your brief. One is that the city is kind of anti-poor, and I consider that unproven, and I have approached that with a lot of skepticism. The other theory that may have some more validity is that this is a sort of cheaper way of doing an urban renewal if you can go in and pursue a zoning violation as opposed to some kind of condemnation action or redevelopment action, or actually going to Mr. Ogden and buying the property from him. And that does strike me as kind of odd that at least it looks like since 1963 it's been the same situation, but now it's suddenly a zoning problem. I mean,
well, Your Honor, when I'm talking about gentrification, I'm also talking about urban renewal, because gentrification can be done appropriately and it can be done unconstitutionally. The appropriate way to do it, and the way we did it back when I was with the city in the 80s, is we did a lot of urban renewal. And in a case like this, I have no problem at all if the city says, this is underdeveloped property, this is property that's not being used to its highest and best use. Let's designate it as an urban renewal area. Let's designate it, let's acquire it, let's pay Mr. Ogden for the land, let's pay the owners of the mobile homes for their relocation benefits. Everything would be fine. But that's a part of gentrification. That's the right way to do it. What the city's trying to do here is trying to get the gentrification done without having to pay for it. And Mr. Ogden may have to pay $300,000 if this decision's affirmed, to deal with the leftover mobile homes that these people can't afford to move. Again, the city attorney, the key witness in this case, I would never bring a case like this as a city attorney if I didn't have the city fire marshal 100% in my corner. And we had an honest fire marshal who gets up there, and he's the city's key expert witness, and he refuses to go along and make any false statements that this is a fire hazard. This isn't a fire hazard. There may be debris, there may be some distance problems between the mobile
About
homes.
additional structures. I mean, I think the debris is off the table, but there have been some extensions, I gather. I mean, additional structures, I'll just call them, on some units. To what extent does that cause you a problem?
Again, the city has, if that comes up and I'm the city attorney, I'm gonna file a municipal infraction case to say you've put if it is illegal, you've put an illegal structure on there, and you're gonna be liable for a municipal infraction if you don't take it down.
I understand.
I'll guarantee you they take it down.
Well, I understand there's that alternative approach, but the question that's really served up to us here, I think, is number one, there's a question of fact, and that is when did the pods get in place? Assuming that the use was present before 1955, the question then becomes, has there been a substantial change in the use? And not merely an intensification a little bit, but has there been a substantial change? If there were enough structures added on so that the square footage of housing in this trailer park doubled, the city might have a case.
I agree, Your Honor, but none of that was in the record.
What does the
Again,
re-
it's all this is red herring. This is red herring stuff. The most important thing to get in the record that isn't in the record and really denies the city the legal right to try to abate this nuisance by destroying the mobile home park is they never went. As a city attorney, you go to the people that are being, whose safety is at issue, and that was the people in the mobile home park. They refused to even discuss it with the mobile home park people, and when I finally got one of them to come forward at the day of trial, they strenuously argued that that person shouldn't testify. That's where their case is damned, and that's where their purposes are false and a sham. You have the obligation, if you're going to terminate people's homes and get them out, at least they have the right to testify as to whether they even think a nuisance and a safety issue is present. Thank you.
Thank you as well, counsel, and thank you again. The case of City of Moines versus Ogden is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.